Well, good morning again. This is Mark Platten. Again, I'm with Colorado State University Extension, and Extension is an outreach of the university. We bring research-based information from the university into the hands of the people. So today, we're talking about water laws and water rights. Now, really in relationship to gardening and to maybe property and ownership of lands. Colorado is kind of considered a first in, first out, or FIFO kind of water use or water law. So those people who first came and used that water have first call on that water. They're what are considered senior water rights owners with that. So in essence, what ends up happening is that the rain that falls from the sky doesn't belong to the property owners, it belongs to the people as a whole of Colorado, and even beyond that to some of the senior water rights owners. You will be either an exempt well or a non-exempt well. So those are kind of the two broad categories. Within the exempt realm, which most of us are, there are two categories. There are the household well permits and the domestic well permits. And those kind of came into play as of May 8th, 1972. It really ties to what the water laws are. So the domestic well permit, you can water up to an acre of produce or orchards or anything like that. And you can also water your livestock, you can wash your cars, you can do all that stuff outside. That's called a domestic well permit. Again, for 35 acres or more, which is why these large parcels of land get broken down into 35-acre parcels. The second exempt case is what's called the household well permit. So that's for, again, anything under 35 acres. The household well permit only allows you to use the water inside your house. You can circumvent this a bit by having a cistern or a couple cisterns on your land, fairly inexpensive. Bring that water in and water your gardens, water your livestock, water your animals, those kind of things like that, and you can get around that. If your well was in place before that May 8th, 1972, then you may be able to be grandfathered in which case you would fall under the same kind of regulations, even though you only have a 10-acre plot, that you would fall under that domestic category, so you are able to water outside. As of right now, we are still under the 2009 laws, which govern whether we can collect rain in rain barrels. So right now, all you can do is use that water in the same way that your permit allows you to. So even though you're gathering it off your roof of your house, you can only use it inside your house. Last year, 2015, there was a bill proposed by our state house that proposed allowing us to use rain barrels to collect water off our roof to use on the exterior, regardless of what your domestic or household well permit said. At that time frame, assuming all the law go through and everything, that this law does pass, then at that time we can collect 110 gallons in no more than 2 containers, and it has to come off a single resident house or up to a maximum of a 4-plex. If you still have questions about these areas, as many of you very well may, then our suggestion is that you either contact myself at CSU Extension. I'll help provide some of the resources. But some of the best places to go to are if you've got a really strong real estate agent that you've been working with on purchasing a property, if they know their background and stuff, contact them, have a dialogue with them, contact really the state water board. And another great resource for you is the county departments here. The Teller County Planning Department has all that information for you on your well. They can help you walk through that, give you the tools, the techniques about what they need to do to make sure they're within compliance or not.